My name is Sarah Levin. I'm the Director of Grassroots and Community Programs at the Secular Coalition for America, and I am very pleased to introduce our presenters today. We have Allison Gill, the Legal and Policy Director at American Atheists. We have Nick Little, the Legal Director for Inquiry, David Niosi, the Legal Director at the American Humanist Association, and Andrew Seidel, the Director of Strategic Response at the Freedom from Religion Foundation. Thank you so much to our presenters today for clarifying what has been a bit of a confusing decision that came down on Monday, June 4th for the Supreme Court. I am not going to delay any further. I just want to remind everybody that you can ask questions in the chat box. I will be paying attention to those, and we will have plenty of time for a Q&A at the end of the presentation. So with that, I'm going to turn it over to David Niosi.
Thank you, Sarah. Okay, everyone, let's kind of delve right into it here. Let's start with a little bit of a factual summary of what the case is all about, and we'll take it from there and go into the legal issues. Basically, the Masterpiece case involves a same-sex couple that went to a cake shop in Colorado hoping to have a wedding cake made. The baker refused to make them a cake, citing his religious objections to same-sex marriage. The couple filed a complaint with the Colorado Civil Rights Commission claiming discrimination based on sexual orientation, which is illegal under Colorado's anti-discrimination statute. The baker, for his part, claimed that two fundamental freedoms allowed him to refuse service to same-sex couples: his free speech rights and his religious liberty rights. The case worked its way through the Colorado legal system, with the claimants, that would be the same-sex couple, winning at every step. They won with the State Civil Rights Commission, and they won with the state courts that reviewed the commission's decision. The U.S. Supreme Court, however, disagreed. That's why we're here today. That court, in a 7-2 decision, reversed the state court finding and ruled in favor of the baker. Now, let's discuss some additional facts that are potentially relevant to the discussion. These facts were cited by the Supreme Court in their opinion, so obviously they are relevant. First, at the time the couple entered the bakery and asked for the cake, same-sex marriage was not legal in Colorado. The couple actually planned on going to Massachusetts to get married, and the Supreme Court cited this fact as something that they weighed in their decision. We could question why, and we probably will. Also, there is no evidence of exactly what, if anything, the couple wanted the cake to say. There is no evidence about the words or symbols that the claimants wanted on the cake. Nothing about the specific design of the cake. Also, the baker insists that he was willing to sell a generic cake off the shelf to the couple, only that he would not use his artistic talents to design and make a cake specifically for a same-sex wedding. Now, in finding that the baker violated the Colorado anti-discrimination law, the state courts pointed out that a merchant who voluntarily decides to participate in commercial activity in a community generally cannot rely on claims of religious freedom to violate a law that is otherwise neutral and generally applicable. They cited a well-known case to lawyers called Employment Division versus Smith to support them. And that would have been the end of it, except that the Supreme Court decided to grant cert and review their decision. SCOTUS, of course, saw it differently. And for more on that, I want to turn it over now to Andrew Seidel.
Thanks, David. So I'm going to discuss the opinion, and then I'll pass it on as well. Basically, the court gave the bakery a get-out-of-jail-free card. Now, as Dave mentioned, there were two big questions in the case, two questions that the Supreme Court accepted the case to actually decide.
You're having echo, Andrew. I'm not sure if having speakers on.
David, do you mind muting yourself, because that might be echo on your laptop?
Is that better? Okay.
Much better.
So basically, as David said, there were two big questions in the case, and those were the two questions that the Supreme Court actually accepted the case to decide. First, does the bakery have a free speech right not to make a cake for the gay couple in their wedding? Second, does the bakery have a religious freedom right not to make a cake for a gay couple in their wedding? The court did not answer either of those questions. So it did not give the bakery or the religious right the win that they wanted. Instead, the court basically just gave the bakery a get-out-of-jail-free card. So the 5-judge majority and the 2 concurring judges said that the Colorado Civil Rights Commission disrespected Phillips's religion. They were hostile to his religion. So here's how Kennedy put it. He said, the question of when the free exercise of his religion must yield to an otherwise valid exercise of state power needed to be determined in an adjudication in which religious hostility on the part of the state itself would not be a factor in the balance the state sought to reach. That requirement, however, was not met here. Now, Justice Ginsburg wrote in the dissent, which Sotomayor joined, and they were clear that there was no evidence of hostility, and I'll touch on what that evidence was in just a moment. But basically, what this boils down to is the commission was mean. They disrespected the bakery's religion. It was an issue of tone, almost. Sarah Huckabee Sanders said in her briefing the day after the case came down that the Supreme Court rightly concluded that the Colorado Civil Rights Commission failed to show tolerance and respect for the bakery's religious belief. Failed to show tolerance and respect. Or to quote Kennedy in the majority, this sentiment is inappropriate. So this was about tone and about propriety. Now, that hostility almost certainly did not exist. In my mind, it was very clear that the court manufactured the hostility. They went out of their way to find this hostility. And there were 2 basic things that the court relied on. The first was a troll in Colorado who went around trying to get bakeries to put anti-gay messages on cakes. Nick is going to talk more about that, so I'm going to let that one sit on the side for a moment. And the second was that 2 of the 7 commissioners said some mean things about religion. Kennedy actually quotes the commissioners in his decision. The first quote is really a throwaway quote. The commissioner was paraphrasing a New Mexico Supreme Court decision in a similar case involving a photographer, and it was a good quote. It accurately reflected the law. The second quote is now infamous, and I'm going to put it up here on the screen so that everybody can see. And Kennedy actually raised this issue in oral argument as well. This is a statement from Commissioner Rice. You can read what she said right there. The phrases that really seemed to resonate most with Kennedy were that freedom of religion and religion has been used to justify all kinds of discrimination throughout history, whether it be slavery, whether it be the Holocaust. And to me, that is one of the most despicable pieces of rhetoric that people can use. That seems to be what really resonated with Kennedy. He actually cut off in his opinion. He didn't add this last line that Commissioner Rice said, where she said, "That's just my personal point of view." But I think it's important to note when this statement was made. So first of all, this was one commissioner making this statement, and the Colorado Civil Rights Commission had already written its order in the case. They were only discussing a motion for whether or not to stay that final order, whether or not to hold off issuing it. So the order was drafted, the bakery had responded, the bakery decided to appeal it, and notice of appeal was already given. So it was not actually part of the adjudication in the case. It was an afterthought that this commissioner mentioned. And more importantly, her comments are true. Religion has been used to justify slavery and murder. So that's one of the reasons that this decision reads a lot like a punt to a lot of the attorneys who were following it closely. I think it's more of a missed opportunity. You know, the Constitution has never given a religious right to infringe the rights of others. And our courts have always held that to be true. You know, under our Constitution, the right to believe has always been absolute, but the right to act on that belief has not been. And it's always ended where other people's rights begin. Religion has never been a license to discriminate, and the Supreme Court could have easily stood on that long-standing principle, but it chose not to. And we'll talk more about the impact and stuff, but I'm going to let Allison take it over now to start touching on that.
Thank you so much, Andrew. I'll try not to be too repetitive of things that have already been said. So this was a really rather unique ruling in which it basically determined that the free exercise clause was implicated by the failure of the Civil Rights Commission to consider the case without anti-religious bias or animus. And the other case that's sort of on point in this area, is a case by the Supreme Court called the Church of Lukamai Babalu I, which involves an issue about the sacrifice of animals and the practice of Santeria. So there was a city where this church wanted to sacrifice animals as part of their religious worship, and the city was completely against it. They crafted an ordinance to specifically target the behavior of this one particular religion to prevent them from sacrificing animals. And the Supreme Court, when looking at the issue, said, okay, this is not a general rule of neutral applicability, a neutral rule of general applicability. This is instead aimed at this particular religion. And therefore, they applied a different standard for this analysis than they do for other analyses versus, under Employment Division v. Smith. So they said, okay, in this case, if you're going to target a particular religion, you need to have the restrictions be narrowly tailored and a compelling government interest. So it's a very different standard than the sort of rational basis standard that is normally used. Now, in this case, the record was littered with examples of animus against this particular religion. For example, there was explicit resolutions criticizing the practice, to hostility by residents at city council meetings. There was taunting of members of the church by public officials and threats to put members of the church in prison. The police chief called it a sin, foolishness, and abomination unto the Lord, and the worship of demons, and declared the church should not be allowed to exist. The city also passed a resolution that said this community will not tolerate religious practices that are abhorrent to its citizens. So, okay, you can clearly see a record of moving forward of animus. Now, with this case, as Andrew was saying, it's fairly different, and the record of animus is pretty slight. It seems like they're using a completely different standard for Christianity versus other religions, which is unthinkable, but in this case is what seems to be what's happening. So Andrew put up the language. Let me just put that back up here. There we go. So this is how the Supreme Court characterized this language. Some of the commissioners at the commission's formal public hearings endorsed the view that the religious beliefs cannot be legitimately carried into the public sphere or commercial domain, disparaged Philip's faith as despicable and mischaracterized it as merely rhetorical, and compared his invocation of sincerely held religious beliefs to the defense of slavery and the Holocaust. So is that an accurate reading of this? I would say not. This is a fairly mainstream example of someone saying basically, well, using religion to discriminate is wrong. And that's something that, people say all the time. It's something that advocates say, that a lot of lawmakers say, that judges often use. That can hardly be framed as animus. So the issue arises that basically this level, saying that is animus, sort of manufacturing animus, as Andrew was saying, it limits the free speech of other lawmakers, of judges, of commissioners, of other people to talk about religion and its harmful effects, potentially, so that it's, because if they do so, it might be characterized as animus. Ironically, although the representatives of Baker here say this case is about free speech, but in many ways it might actually limit is causing a negative outcome without it being considered animus.
Allison?
Yeah.
Allison, can you repeat the last 10 seconds of what you said? You cut out for just a second there, I think.
Oh, okay. I was
just back up a bit.
Sure. I was saying that, although the Baker sort of portrays this, the representatives of the Baker portray this as a free speech issue. In fact, the case may limit the free speech of judges, of lawmakers, of other people in those positions of responsibility, because if they can't criticize religion potentially without it being seen as an example of animus, which might impact their judgments people are making or laws people pass. And if they can't talk about the negative impact of religion without it being, considered animus and violating potentially the free exercise claims of the people bringing cases or the defendants. And this is already being applied in some cases. The Alliance Defending Freedom, ADF, is claiming, for example, in one case, that comparing discrimination against an LGBTQ person to racial discrimination is an example of bias. So I'm not sure if I'm framing that correctly. I think you might have the link and show, Andrew, but basically they're sort of framing it that even making this comparison perfect is an example of bias, which will greatly limit the ability potentially to enforce these types of laws. And yeah, so basically by manufacturing this animus claim, the court has created confusion in the law, potentially limited the free speech of anyone critical of religion. And if officials can't be critical of religion at all, then they don't really have religious liberty or free speech. So we're pretty concerned about that aspect of it. Nick seemed to be not there. Nick, can you hear us? Perhaps
I wonder if he just used Cameron to duck out for a second, because it looked like it was lighting up green there. Nicholas?
Technical issues. We apologize, folks.
Well, while we're waiting, Allison, I'm just going to do my favorite Lukumi quote was the city council president actually said, "What can we do to prevent this church from opening?" It's just, I mean, that encapsulates everything. And, you know, I mean, to compare something like that to these throwaway passing moments from the Colorado Civil Rights Commission is just, to me, it lowers the bar for what, there's Nick, constitutes hostility to levels that just about anybody can reach.
Hey, Nick, can you hear us okay?
I'm wondering if we should take some questions, and then if Nick gets back on, we can give him.
Yeah, I think I'm okay with that. I think that's a good idea. Maybe we can have Sarah work in the background to see about.
Yes, agreed. I think we should do that. I haven't seen any questions yet in the chat box. So please take some time. Oh, I do see someone typing.
Sarah, while you're doing that, Nick just asked for the phone number he can call into. Maybe you can email him one?
Yes, I did see that. I'm working on it.
And I'll just mention one other thing that I found strange about this case. There were a couple of procedural issues with the case that were very weird, which I was going to not mention just because it's maybe not as exciting for lay people. But you know, this was an appeals court decision, and the appeals court reviewed the Colorado Commission's case de novo. That means they looked at everything to determine you know, whether or not the decision was appropriate. And they didn't find that there was any hostility. And what the Supreme Court should have been doing was not looking at the Commission's decision, but looking at the court's decision to see if there was actual hostility towards religion. And they didn't actually do that. And the second thing was that the hostility issue was not really briefed. The only place it was really fully briefed was in an amicus brief that Doug Laycock wrote. The state didn't really defend the argument and didn't really seem to think they had to. I mean, I actually went back and looked, and in the petition for cert, there's about 3 paragraphs on hostility. And really, total, I found 11 paragraphs and 1 footnotes in about 350 pages of briefing from the principal parties in the United States, and that's it. I mean, this was not an issue for the parties, and the Supreme Court, for whatever reason, seized on it to decide the entire case, which is, it's strange, especially since it was not, hostility didn't seem to be in the 2 questions that the court was going to answer. So some of your questions we may not be able to answer. There was something, I think, happening behind the scenes here that we don't know about, and maybe we'll never know about, certainly not for a while.
I think you're right, Andrew. Most people following this case, I think, believe that if the baker was going to win, he was going to win on a free speech claim. In fact, there are some liberals, especially in the entertainment industry, where free speech has a kind of a special commercial importance, if you will, who actually sided with the baker on the free speech issue. I don't think many people in the secular community did, but there was kind of a sector out there of even liberals, as I said, especially in the entertainment industry, who are kind of rooting for the baker here. And most people following the case, I think, thought that if the baker prevailed, it would have been on the free speech claim. The fact that the court decided to look at the hostility to religion issue is the real concerning thing about the case, as far as I'm concerned. It really shows that not just a slim conservative majority, but we've got Kagan and Breyer as well, willing to go along with this exaltation of religion. We're not allowed to touch religion. We're not allowed to express any hostility to religion. Otherwise, you get, as you said, a get out of jail card. That to me is the really concerning thing about this case.
So we had a question, it looks like, about the breadth and applicability of the case from Karen. I'll just repeat the question so people can see it. The nuances of this case from a legal standpoint are interesting. I'm not an attorney and find it challenging to keep up. My limited understanding was the Supreme Court decision is basically extremely limited and applies solely to this case. However, I hear the ramifications being discussed in the future and impact of the decision. And so, yes, the decision itself was fairly limited to this case. The opposition really wanted them to invalidate non-discrimination laws based on, for people conducting expressive conduct. So people like artists and other people engaging in expressive conduct based on a free speech theory. And the court declined to do that. They not only declined to do that, but talked about the importance of, there's a lot of text about the importance of non-discrimination laws, the dignity of LGBT people, the worth and the applicability, and saying, non-discrimination laws can exist and can apply. And instead, they sort of, it was very fact specific. In this particular case, there was animus, and that's why they kicked back the case. That's why they decided against the claimants, because in this particular case there was animus. But that doesn't really give us guidance on these types of cases in the future. Or as much guidance. And, but we are talking about the ramifications because, the sort of framing they use around animus might have a further impact. It's hard to say at this point.
There's a couple things I think you have to distinguish legal and real world ramifications. I mean, legally, we may see the ramifications within the month. There's a good chance that this decision will bear on the decision in the Muslim ban case, which a few scholars are hypothesizing that is why Kagan and Breyer joined with this decision to pull Kennedy into their side on the Muslim ban 3.0. We'll find that out, whether or not that's true. The legal ramifications are going to shake out over a few years. Real world, I think, it's important for two reasons. One, this clouds what is a clear issue. The court, with a little bit of courage, the court could have easily decided, you know what? No, there's no excuse for violating the rights of others that you can base in religion or in free speech. Sorry. And because that has been clouded now, and I mean, you can already see this happening, we know what's going to happen next, right? The bigots and the illiterati are going to run with their misconceptions about this case and about the opinion, and the religious right is going to use this as a roadmap to find maybe a better case or a better vehicle to try to get the decision they want and try to redefine religious freedom into this license to discriminate they've been trying to do for a while. So those are kind of my takeaways from it. David?
Yeah, right. I think there's a very good question here. Why did Breyer and Kagan side with the majority? Why did they concur? And I think your theory is certainly one to consider. I think their decision, if you look at it, that they actually had a separate concurrence, that they joined in the majority, but Kagan wrote a separate concurrence. And it's very interesting because she actually points out that the commission could have sided with the same-sex couple if they had done it right. She basically says that they wrote their opinion wrong, that they emphasized their hostility to religion, whereas they could have pointed out that, under Colorado anti-discrimination law, same-sex orientation is a suspect class, and that, for that reason, they could side that way. In fact, that even allows the commission to distinguish it from cases where people just wouldn't put hate speech on a cake, because the court was also kind of troubled that the commission didn't really distinguish those hate speech cases from this case. So it remains to be seen just how limited the decision is. I'm always very skeptical of people who say that a Supreme Court opinion is going to be very limited, because technically it is limited. In the real world, as you say, the people on the ground don't look at the limited language. You can even look at the Town of Greece case as an example of that. Town of Greece was a case that said sectarian legislative prayer is okay, so long as it's delivered in a certain way, in a certain context. And those limited contexts were things that we really relied upon when we read the decision, to say, well, it's somewhat limited. At least legislators themselves can't say prayers, because SCOTUS limited the opinion to that. But on the ground, even courts, even federal courts, even appellate courts, at least one appellate court has suggested that the limitation on visiting preachers, the prohibition against legislators praying, isn't really part of the decision, that the decision is more broad than we in the secular community decided to see it. So we need to be very careful about assuming that limited opinions are really going to be limited.
I think those are both really good points, and I just want to build on it, talking about the real-world implications. So, I mean, if the opposition succeeds in getting across their message, and they really are portraying this to be like a win for their vision of free speech overwhelming non-discrimination, that is how many people are portraying it, particularly the less careful sort of lawyerly groups in the opposition. But that sort of message will have an impact. It will have an impact on people working to pass non-discrimination laws. They might be less willing to do so. Lawmakers may be less willing to consider passing non-discrimination ordinances locally or in states, especially if they think that there is an impact on religious people, because the Supreme Court is now saying that, which can, that can have a lot of real-world significance. Moreover, people might not bring claims. So if they get across the message, and let's say LGBTQ people or anyone might think, okay, well, this is a situation where I'm just going to lose, because apparently they lost this case at the Supreme Court, so I'm not going to bring a claim and put myself at risk. More people will think that, which means less claims will be brought in all sorts of different contexts. So those will have a very real impact in people's lives on that way.
Yeah, is Nick on, Sarah? I guess not.
Yeah. Can people hear me?
Yeah, he is.
Nick, I was just going to jump in and talk about the Jack case, but if you're on...
Yeah, apologies about that. When Andrew was speaking initially, he mentioned this basically what can only be described as a troll, a certain Mr. Jack, who went around a whole bunch of cake shops in Colorado trying to show how that there was bias. And he went around and he was ordering cakes with messages with anti-same-sex marriage intent to them. And the cake he asked for was essentially an open Bible with quotes from Leviticus on it. And cake shops refused to make these for him. So he sued, claiming discrimination, and he lost at the Colorado level. And Justice Kennedy brought this up, saying, this shows how things were treated differently. Justice Gorsuch, in particular, thought this was a very important thing. If you followed any of the social media posts after the case, a lot of other people thought this was important too. People like the Alliance Defending Freedom, the Beckett Fund, this shows discrimination, but also a lot of people who genuinely should have known better were comparing these two situations. And I'm sure people listening have seen the common thing, what about the Jewish cake shop owner who has to make a cake with a swastika on it for neo-Nazis? Well, the bottom line is that's just not relevant to the case. And it's not relevant to the case for multiple reasons. The first reason is kind of, in a way, a legal cop-out, but it refers to what the law actually is. Neo-Nazis are not a protected class. And honestly, even in our current legal environment, I can't see any state of the United States passing a law banning discrimination against neo-Nazis. Just not going to happen. So that in itself is a flaw, but there's a more fundamental flaw to it, and it shows a misunderstanding of how anti-discrimination law works. Jack Phillips, the owner of Masterpiece Cakeshop, refused to make a cake for a same-sex marriage or a same-sex wedding when he made cakes for opposite-sex weddings. He had no idea what that cake would be. It could have been an exact copy of a cake he'd made a previous week for an opposite-sex wedding. He had absolutely no idea because he never even got into that discussion. So there's no doubt in that case he was refusing to serve the people because of their sexual orientation and because they were taking a cake to a same-sex wedding. On the other hand, the people who refused to bake Mr. Jack's case were willing to design a cake for him. They were willing to sit down and discuss that, but on the other hand, they said, we would not make a cake with this message on for anybody. It didn't matter who came in, whether the person was gay, whether that person was straight, whether that person was transgender, black, white, Jewish, Christian, Muslim. They would not make a cake with that message on. A business, even under anti-discrimination law, is allowed to refuse to provide a service provided that they don't discriminate in who they refuse to provide that service to. So the example I've given recently on this is the case of Dick's Sporting Goods. Dick's Sporting Goods recently announced they would no longer sell semi-automatic rifles. They're allowed to do that. It doesn't matter if you agree with their decision or not. Nobody denies Dick's Sporting Goods has the right to refuse to sell semi-automatic rifles. What they can't do, on the other hand, is sell semi-automatic rifles and refuse to sell them to Jewish people. And they can't turn around and say it's the purpose that that rifle's being used that's the problem. They can't say we sell church defense weapons, but we don't sell synagogue defense weapons. They're just not allowed to discriminate in that way. And that's what happened here. Jack Phillips makes wedding cakes. He refused to make a wedding cake for a same-sex couple. On the other hand, the other bakers who refused Mr. Jack would have refused to make that cake for anyone, therefore it didn't fall under the anti-discrimination laws.
I think that was a pretty good summary, Nick. And I think the religious right did a really good job. That's what I have. Well, the religious right did a really good job, I think, and you and David both hit this, and I think it's so important that there was no free speech issue in this case because the bakery and the couple there was no discussion between the parties about what the cake would look like. And that was in the stipulated facts. They agreed, the bakery itself agreed that there was no discussion between the parties about what the case would look like. And that to me is just a crucial fact that throws out and completely undercuts the free speech argument of the bakery. And I think that if you want to flip what Nick is talking about around, that maybe might help a little bit with the troll, right? The troll is basically saying, well, these bakeries are discriminating against me because they won't make my Christian message. They won't bake a cake that has my Christian message on it. But it had nothing to do with his religion. He was claiming it was religious discrimination, but it didn't matter whether he was an atheist, a Jewish constituent, a Christian citizen, whatever. It only had to do with the message on the cake. Whereas in the Phillips case, it had nothing to do with the message and only to do with the fact that this was a gay couple. The troll, it had everything to do with the message and nothing to do with his religion. So I think Nick kind of hit the nail on the head there. Those were really great points to differentiate on.
There's another question from Wendy. She said, so is it okay to break the law as long as the commission shows animus?
I think that's a great point, Wendy. And basically it means that Mullins and Craig, the people that suffered the discrimination and tried to get the cake, they have no remedy. The court didn't, kick it back to see if there was in fact animus or do a rehearing. They sort of said, it was procedurally odd, as Andrew spoke about earlier, but basically now these two people that undeniably face discrimination because of the actions of these third-party civil rights commission, they are now denied a remedy for the discrimination that they faced, which is unfortunate. Yeah, so I don't know, does anyone have anything else to add to that?
No, I mean, that was the third point of the procedurally odd. I think you hit it on the head. It's that they normally, in this case, the Supreme Court would kick it back and say, okay, do it right without being hostile to religion.
Yeah, I think it's important on that to notice, and this is something to take away from this decision. If this same couple go into this same bakery tomorrow and order a cake,
Oh no.
It was a good cliffhanger there.
I know. I'm waiting for that. I'm waiting for the payoff.
Nick, we lost you.
I'm sorry, I was getting, yeah, if they go in tomorrow, order the same cake, and they refused it, they will win in the Colorado Human Rights Commission again, and
I think Nick is right. I think people understand where he's going, even though we keep losing him. The flip side to that, though, I'll say is, it's kind of what I was talking about with the real world consequences of the decision, is that now the baker knows that he needs to do a better job, and he's not maybe going to not discuss what message will be on the cake. Maybe he'll wait to hear what kind of cake they want, and if they say something like a rainbow cake, he'll say, oh, well, that's not a message that I want to put on a cake. So the Supreme Court has kind of given them, this chance to do it over and do the discrimination right, as much as they've given the Colorado Commission the chance to do their case over and do it without hostility that the court manufactured. So that cuts both ways, I think.
There's also the issue of artistic talent. Sometimes the express content of a message is less important when somebody can claim that their artistic talents are being tapped for commercial use. And I think most of us agree that if you're a true artist, you should have the discretion to do the art you want to do. If you're a portrait painter, for example, you can pick and choose your subjects, and you perhaps don't have to paint anyone who comes through the door. That's just the reality of life and art. If you're throwing a production, a play or something like that, sometimes you would select actors based on terms that might consider discrimination based on sex, race, whatever. That sort of thing does happen. The issue here of whether a bakery can hold itself out as an artist, that is still an issue that's open. We could resolve all the religious issues, and the court could still take a look at the free speech artistry issue and go the wrong way on it. And I think it's very dangerous, because if a baker is an artist, how far away is somebody who builds houses? Isn't there a little bit of art to the job of building a house? I mean, a good carpenter can almost be like an artist. Can he say that, I only want to build for a certain demographic? So, these are all issues that are still out there, and you can bet that the other side on this issue is going to try to draw the line in as discriminatory of a way as possible.
I see that Nick is back. Nick, did you want to add anything else regarding your points? You sort of got cut off a couple times there.
No, I'm good at the moment. Thank you.
Okay. Well, one aspect that we talked about briefly beforehand that we didn't really mention was how this was sort of a pro-trolling decision, and I thought Andrew and Nick both raised good points about that. Maybe you could talk about that a little bit more.
Well, yeah, I mean, it incentivizes trolling. If you're this guy out in Colorado, Mr. Jack, you've just been mentioned in the sort of culture war Supreme Court opinion of this term. You were mentioned in every one of the opinions, and I mean, I haven't seen his reaction, but I can imagine what it is. So I think what the court did was, this was a big signal to all the trolls out there to, go get involved in these cases and raise hell, basically. I think it was a terrible idea. on the court to put so much stock in this, especially since they all knew it was completely legally different, and they even said that. I mean, that was the concurring opinion said, yeah, this is legally different. You should have done a better job, Commission, of pointing that out. So I mean, it's really frustrating to read.
Are there any other questions from our participants? I'm wondering if maybe, oh, wait, we see some typing.
Yeah, we got a couple. Oh, hi, Claudette. Oh, they didn't ask. Yeah, there it is.
Just wait a moment for them to finish typing, and then I think it would be great what we can answer their questions, and then if we could maybe tie it together for the participants, you know, what does this mean moving forward for religious freedom and the separation of church and state? Are we going to see more cases brought forth like this? I think a lot of people on the call kind of just want to know, what does this mean for us as secularists? So, Claudette, that's a thank you. Great summation of the case and decision. Thank you, Claudette. Thank you for participating. And then if we have no more questions, maybe we can tie it together.
Yeah, I actually have to duck off to head to another meeting. So, I mean, I'll just reiterate what I said before, which is I think this is a narrow decision. It's a punt. They could have done a better job. I suspect we're going to hear they're going to decide a case along these lines like this in the near future, and I'm going to be keeping an eye on the Muslim ban case to see where that's going to go. But the immediate real-world consequences, as we already discussed, you know, this is going to be, I think, problematic. I think a lot of people are going to take this as a license to discriminate when it's not. Thank you for having me. I hope this helped everybody.
Thank you, Andrew. I agree with that last sentiment. I think that all of our groups, the civil rights groups, the LGBT groups, secular groups, really need to be at the forefront and saying, you know, it was not a broad decision. It was a very narrow, fact-specific decision, and we need to get that point across that, you know, non-discrimination, civil rights laws are still valid. They need to be enforced, and we don't know the full repercussions at this stage of the free speech implications and how this will affect the ability of lawmakers and judges and commissioners to speak out, but it's something that we're at least very concerned about. David?
Yeah, I think to wrap up, what I would suggest is that we all remember the importance of our non-legal work.
I would worry in particular long-term effects on their.
Is Nick there? Oh, I'll continue then. What I was going to suggest is that, you know, we need to realize that we can't necessarily always rely on the court.
Yeah, I'm sorry. Everything's coming through with a big lag on the phone. So.
Nick?
David, why don't you finish your point? And Nick, how about you type it out, and we'll just read it out to close.
Sure. My point was that we need to remember that we can't always rely on the courts to resolve these cases the right way. Obviously, we want to bring church-state cases, and we want to be aggressive, and we want to win. The reality is that, especially among the older generation, and you have to remember that most judges are in the older generation, there's a sense in American society that religion is extremely special and that religion needs to be exalted, and we can't question religious privilege. These sentiments are not going to change in the courts real fast, especially since the Supreme Court issued this decision. We as activists really need to be mindful of the importance of spreading the idea that religious privilege needs to be questioned and that religion can do harm and that religion is a vehicle for discrimination. And I think if we do that effectively and communicate it well, we will start seeing more progress on the legal side as well.
Great, and I know Nick is still typing out his final thoughts. Allison, do you want to share your final thoughts?
Oh, I just did a moment ago. I don't have anything else to add.
Sorry. Okay, here we go. So Nick is saying that his concern is what happens long term. We have 3 justices who are committed to religious supremacy based on this decision, meaning Thomas, Alito, and Gorsuch. He says that Kennedy was wrong here, but if we lose Kennedy and Ginsburg off the bench, They're replaced with Gorsuch think-alikes, and then we have a huge problem, which I think is a great way to close with a call to action, which is that, you know, elections have consequences. Midterms are coming up. All of the organizations that were represented today have ways for you to get involved. And so please do keep in touch, follow the issues, and get involved in the organizations represented today, because we certainly have a lot of work to do. If you have any additional questions after the call, you know, feel free to get in touch with us. We're happy to answer your questions. And thank you all for being on the call. Big thank you to all the presenters today for clearing up this confused decision and teaching us all about what it means for us moving forward. Thank you.
Thank you.
Thank you, Sarah, for hosting. Bye, everyone.
Bye-bye.